Good morning, everyone. Here are the problems. Let's continue the conversation with this decreto-legge. Here are the problems that I have as a political scientist and many of attorneys that I have talked to. I'm a political scientist. I'm a thought leader, but I have conferred with attorneys. It is a problem that we have and we will address with the parliament members very soon. First of all, for decreto-legge to happen, there must be the urgency and necessity premise. There's no such a thing. Consulates, there was no backlogs in the consulates. Consulates for 30 years, they have been reviewing one file a day. They had a standby system, some of them. Some others, they had appointment systems, so they were asked the applicants to send a file. It takes 20, 30 minutes to look through documents and see if you're eligible now. So I'm not understanding what is the consulates and consulate general's issue on this topic. And I will address it also with the consulate generals of in US, different parts of US. Secondly, there is no backlogs in the town. The towns were processing the files they could. 2, 3, 4, 5 days per year, files per year, even more, depending on their workload. The judicial backlogs could have easily been solved by, like I said, like I talked to it, like I proposed, with creating an original session for citizenship, hiring judges, hiring workers, creating jobs. That's how you solve problems, with creation, not denying the rights of the people. Part 2, the retroactive impact and limiting fundamental rights. The law applies retroactively by stating that even individuals born before the decree enactment and already recognized as Italian may be considered not to have acquired citizenship. This is against the Constitution, the right of citizenship granted by the Constitution, which is the foundation of the whole government, the whole system. The Italian Constitution is the mere foundation where everything else stands. And no law, especially decreto-legge, can go against the Constitution. That's why we need to send this decreto as soon as possible to the Corte Costituzionale if it gets approved. I doubt it, because this is shameful. This is not a product of smart, intelligent, understanding, knowledgeable individuals. This is not. Number 3, it's a discriminatory or an arbitrary criteria. The exceptions outlined create a class of exclusion based on circumstances outside the individual's control, such as place of birth or date of application. It raises constitutional concerns under the Article 3 and 4 of the Italian Constitution, which states the equality and the right to defense. 4, procedural burdens and restrictions. Now, the legal procedure under Article 19 bis are made more stringent. No testimony or oath allowed. Burden of proof lies entirely on the petitioner, disproving reasons for loss of non-acquisition. This is a major depart from standard civil procedure protections, and it may disproportionately affect individuals without legal expertise. Number 5, national security justification. There is no security risk to the national or diaspora. This is a wealth of investment. These people are coming to Italy, investing, buying properties, bringing their knowledge, their culture, their American, Italian-American culture, their wealth of knowledge and culture and understanding. They're bringing money to the local towns, to the grocery stores, to the bars, to the restaurants, to the hotels. They're traveling to Italy. They bring in wealth. They are contributing to the well-being of the country. Where is the national security risk? You have politicians have to explain to me, where is the risk? What risk are we talking about? because some backlogs from the judicial branches, some courts, or a couple of consular generals are complaining, you deny the rights, you cut off hundreds of thousands of potential investors. These are investors coming into your country, our country, to make our world better for our youngsters, for our younger generation especially. What are we doing here? What is happening? These are people that are connected to Italy. These are reparations from the diaspora, where millions of Italians were forced out after 1860. And the kids, grandkids, and great-grandkids have the right to return. They have the right to claim their citizenship, as stated by the Constitution, as stated from the constitutional strong law of 1992, which is not a constitutional law, but however, it has a strength that cannot be amended by few lines. Number 6, and final, where is the administrative overload as a justification? Where is it? Where is the administrative overload? Somebody gotta have to explain me. Create a special sessions. Handled in 1948. Consulates in U.S. or everywhere, all over the world, could set up standby appointments. You set up standby appointments. Then each day, you review 1 file, 2 files, or 3 files, whatever files you want to remove, but you have to work, consular workers. I mean, that's your job. That's part of your job. That's why you get money from the taxpayers. So where is this overburden? This decree will be destroyed by the Corte Costitucional and will not withstand the European legal scrutiny, the European Court of Justice. So we have to rally. I'm contacting all the Italian American organizations all over the country, see who's going to stand up. I'm contacting the ambassador. I'm contacting the Ministry of Foreign Affairs of U.S. because this is affecting 100,000 people that have paid money, that have believed in their heritage, in the law that was in effect. They invested their time. They invested their part of their soul as well. We cannot treat people like this. This is unjust, unfair, regardless of a direct economic interest they have into it. This is unfair. This is immoral, unethical, and also against the Constitution. Article 3 and Article 24 are evidently and obviously affected by. Having said that, we are now looking, just try to figure out where is this decreto-legge, which committee of the Parlamento is, where we will contact each of those members for those committees to let them know our opinions professionally, peacefully, and candidly, as always. We will share the information, so we urge everyone to email, contact the member of the parliament and let them know that this has to go. It has to be changed. Eurosanguis has to be restored as it was, and solutions to the backlogs, simple backlogs, can be put in place, like a creation of a special section for the courts, standby list in the consulates, standby list that will not create an additional legal actions. In fact, these will create even more backlogs at a judicial level because people will appeal these. So we are doing the reverse. The results are the opposite. So let's just, everybody come down to the common sense, using our human logic, and see how can we solve this slight backlog. Consulates, there is no such a thing. I've been following consulate operations for years. They just review 1-2 files a day. You don't see lines of consulate people knocking on the door of the consulate, pressing them. Nobody's doing anything like that. They're waiting for their turn until their files is being reviewed. So call for action. Follow me. I want to look, search now. Where is the decreto-legge, in which committee it is, because first it has to go through the committee review. I will let you guys know. I will share the emails of the parliamentary members, so you can voice your opinions. Stay in touch. Subscribe, share it with family, friends, interested in individuals, anybody you feel like they can benefit or they need to know what's going on. Share, and subscribe. Dr. Domenico Meschino here. Domenico said, we'll talk to you soon.